Defendant Zachary Vozzella. Now, he's charged with murder for the stabbing death of his brother's pregnant girlfriend. The victim, Brianna Welsh, was 3 months pregnant when she was found stabbed to death in July.
A maintenance worker found Welsh's body in the apartment that she shared with her boyfriend, Brianna Welsh, and his brother, Zachary. Welsh had cuts and stab wounds.
Now, a big part of the case centers around what happened hours before Welsh was murdered. That's when she had reported her boyfriend, Brendan, for a domestic violence attack. Now, she was treated at the hospital, then sent home. Her boyfriend was arrested and was in jail at the time of her killing.
Police arrested Zachary Vozzella after record from a key fob indicated that he and the victim were the only two people in the apartment when she was stabbed. Police say they found bloody clothes and a knife from the apartment in his belongings. Vozzella eventually admitted to being in the apartment, but he claims he never saw the victim and that he did not kill her.
Yeah, he told a series of lies to the police, which he eventually admitted to. Now, this morning, we're bringing you a bond hearing for the defendant, Zachary Vozzella. This hearing held earlier this month. Let's pick up the hearing from the start as the prosecutor goes over the allegations against 26-year-old Vozzella.
Commonwealth is asking that you hold this defendant without bail. He's charged with first-degree murder. Just to give your honor an understanding of the case and the facts, on July 30th of 2024 at approximately 11:12 in the morning, the Lynn police responded to the apartment complex located at 254 Lynn Way after the victim of this homicide, Brianna Welsh, reported that she had been assaulted by her boyfriend, who is actually this defendant's brother, Brianna Welsh. While the police were on scene, Ms. Welsh was upset and crying. She told them that she did not want to press charges against her boyfriend, but she did want to go to the hospital. She indicated to them that she was 3 months pregnant with Brendan's child and wanted to make sure that the baby was okay. She was transported to Salem Hospital, where they determined that she and the baby were fine after completing an ultrasound. The Lynn police returned to the Lynway apartment that Ms. Welsh resided at with her boyfriend and arrested Brendan Vozzella, this defendant's brother, at 2:20 p.m. on the 30th. Due to Massachusetts law requiring a mandatory 6-hour hold on domestic violence offenses, Brendan Vozzella was not able to be bailed by a clerk until approximately 8:30 that evening. Ms. Welsh arrived home to the Lynway apartment at approximately 6:10 p.m. on the 30th based on information received from the cab company that dropped her off, as well as key fob entries into her apartment. The Lynway building is a relatively new building and actually utilizes key fobs for residents to gain entry both to the building itself as well as their individual apartments. So there's a key fob system that actually records every time an individual apartment door is locked and unlocked, as well as a key fob activated to utilize to enter or to lock that particular door. On July 31st, the following morning at approximately 8:30 a.m., Ms. Welsh's mother contacted maintenance at the Lynway building to ask them to check on her daughter. She indicated that she had not heard from her since around 5:30 p.m. on the 30th, before she actually left the hospital, which she indicated was unusual for her daughter. She also later told investigators that she had not seen her daughter active on Facebook Messenger after that time, which she also felt was unusual. Maintenance workers entered Ms. Welsh's apartment at 8:57 a.m. on the 31st, and that's based on data obtained from the key fob system. They found Ms. Welsh unresponsive on the floor of the single bedroom in the apartment with apparent stab wounds. There were no knives or weapons located around her. The medical examiner ultimately determined that the cause of death was sharp force injuries after an autopsy was performed, and informed investigators that Ms. Welsh had multiple potentially fatal wounds to her torso area, as well as 3 stab wounds to her back. She also indicated to investigators that the wounds that the medical examiner observed were consistent with a steak knife based on the paths and the sizes of the wounds. Investigators were able to determine that Ms. Welsh used her key fob to enter the building at 6:10 p.m. on the 30th after she returned home from the hospital, and then unlocked her apartment door with the same fob at 6:15 p.m. Thereafter, the apartment door was unlocked from the inside at 7:50 p.m. and locked again 1 minute later. Then the door was unlocked from the inside again at 8:15 p.m. and locked at 8:16 p.m. from the outside using one of the key fobs that was assigned to Ms. Welsh. The apartment door was not opened again until maintenance workers discovered Ms. Welsh the next morning at 8:57 in the morning. Brendan Vozzella was also not released from custody at the Lynn police station until 8:32 p.m. on the 30th. and he was tracked on various surveillance cameras throughout Lynn as he walked from the police station to his cousin's house at Husk Court, where he spent the night. Brendan also did not have a key fob in his property when he was arrested. So the evidence was clear that Brendan did not return to the Linway apartment building after he was arrested on July 30th.
Still with us, criminal defense attorney Jack Rice. All right, Jack, how do you defend this? Because the key fob records show that the defendant brother was the only one in the apartment at the same time as her. Maybe I could argue the key fobs were stolen, etc. But here's what we know from the incident report and some of what we just heard. Kitchen knife was found with him, a pair of shorts presumptive for blood with him, and the 2 lone working key fobs found in his stuff. What kind of defense do you mount?
Oh boy, it's that last one you made that actually is the most concern to me is the 2 key fobs. The fact that the 2 working key fobs are in his possession. And if you listen to what the prosecutor just laid out, first of all, she's the one who opened that door, apparently, when she allowed somebody in. And when somebody left, obviously not her, they took hers and maybe the other one too. So that's a real problem. This is going to be difficult. You're going to have to argue something else, that there are more key fobs potentially, that there was some other person. You're going to have to find some other alternate perpetrator. These can be extraordinarily hard. When I first start with cases like this myself, one of the first things I'm looking at is a bail argument that we're seeing right here. The standard for that is this. You're going to say that this person is a danger to society and that they're not going to reappear. And so you got to be able to keep them. Now, not every jurisdiction allows you to hold them without bail. Some jurisdictions say you must give a bail amount. They don't have to do that here. And so they are holding on to him. And I think they're going to do that probably wisely, because it's hard to say not just how desperate he's going to be, because he should be. The amount of evidence they have may be quite substantial, and I don't think we're done yet.
Yeah, but we're not done. And one of the things they consider in Massachusetts is the severity of the crime.
Yes.
And this is a crime that you could argue included 2.
Yes.
Because she was 3 months
pregnant.
So
that's right. Good point.
Well, and something else too, if you think about that, if you listen to the injuries caused here, we have at least 2 to the abdomen, we had at least 3 to the back. And so what we have is the argument now is you're saying first degree. You're arguing saying this was intentional. It may not have been the first one, may not have been the second one, but the potential is they could always go up. They could always do more. And so that's always the concern here. They're going to put enormous pressure on this person. Yeah. And they're going to really go after them, maybe to back off from the first degree charge. But when you get 5 stab wounds is a lot.
Yes.
A lot. And very personal.
Yeah, very personal.
Many times. All right, Jack, stand by. We're going to take a break. Coming up next, the prosecutor continues recounting what the state believes happened to Brianna Welsh. Will she convince the judge to deny Zachary Vozzella bail? Keep it here on Court TV, your front row seat to justice.
Coming soon to Court TV.
It's the biggest story that we're covering.
He is the boogeyman.
Lori Daybell.
She said, I will have you destroyed.
She's got another murder trial coming up.
A social media sensation, now a suspected killer.
We will not stop fighting. We have no quit.
Sean Diddy Combs arrested on a federal indictment.
The high-stakes trials you don't want to miss. Coming soon, only on Court TV.
Welcome back, folks. We've been listening to a bond hearing in Massachusetts. This was held last week in the pregnant woman stab murder case.
Zachary Vozzella is accused of killing his brother's pregnant girlfriend, Brianna Welsh. Let's go back in as the prosecutor continues to convince the judge to deny bail for Vozzella.
Investigators interviewed Brendan, as well as a cousin of both Brendan and this defendant, who lived at Husk Court, where both Brendan and this defendant stayed on the night of July 30th. The defendant was actually present with his cousin at the Husk Court apartment on the 31st when investigators went there to look for the cousin in order to speak with him. Their cousin told police that Brendan and this defendant had spent the night at his home on Husk Court on the night of the 30th because Brendan could not return to the Linway apartment due to the arrest the arrest for the domestic violence on Ms. Welsh. He also informed investigators that the defendant had been staying with his brother Brendan and Ms. Welsh at the Linway apartment for some time. He further told investigators that he stopped by the Linway apartment sometime after 3 p.m. On the 30th after Brendan's arrest to speak with the defendant about what happened. He said that during that conversation, the defendant was the only one at the apartment and expressed concern to him that he was probably going to have to find somewhere else to live since Ms. Welsh clearly did not want Brendan at the apartment and therefore would not want the defendant there either. The defendant also stated to his cousin that he described what took place between Ms. Welsh and his brother as he had been actually present for the altercation that led to Brendan's arrest. When the cousin left the Linway apartment, he said that the defendant remained there. Brendan confirmed to investigators that he spent the night at his cousin's apartment and did not return to the Linway apartment that evening. He also described the route he took from the station to his cousin's house, which was corroborated by video surveillance. The defendant's father was also interviewed and told investigators that he was visiting his sons at the Linway apartment when Brendan was arrested. He said that he spoke to the defendant at around 8 or 8:15 p.m. On the 30th. And at that time, the defendant told his father that Ms. Welsh said she wanted both the defendant and Brendan out of the apartment and that he had packed up as much stuff as he could from the apartment and carried it downstairs. The defendant also told his father that he was going to take an Uber to his cousin's apartment where he and Brendan would spend the night. The defendant was seen on video at the Linway building, exiting the building with 2 backpacks, a duffel bag, and a trash bag at approximately 8:19 p.m. after the apartment door had been locked from the outside with a key fob at 8:16. He was seen on video walking through the parking lot with these bags, headed towards the location where records from Uber confirm that he was picked up at 8:50 p.m. and dropped off at Huss Court at 8:54 p.m. Video from the Huss Court building confirms that as well, and records from T-Mobile for the defendant's location data associated with his cell phone number are also consistent with this. Snapchat messages between this defendant and his brother were recovered from Brendan's phone and show that after the altercation occurred between Brendan and Ms. Welsh on the morning of the 30th, Brendan left the apartment and asked the defendant to check and see if the police were still in the area at around 11:32 in the morning. The defendant told Brendan he walked around the building and didn't see the police, and during that time, the defendant's actually seen on camera at the Linway building wearing different clothing than he's seen later when he exits the building at 8:19 p.m. and then ultimately appears at the police station in the following day. Warrants were executed at both the Linway apartment as well as Huss Court to search the bags the defendant was seen leaving the Linway apartment with. No key fobs were located inside the Linway apartment, but both of the fobs assigned to Ms. Welsh were located inside the backpacks that this defendant was seen on video leaving the building with. In the trash bag the defendant was seen carrying out of the building, a steak knife was located that appeared to match the butcher block set at the Linway apartment. The blade of that knife tested positive for the presence of blood. Also in the trash bag were shorts and socks consistent with those that the defendant was seen wearing on video earlier in the day on the 30th after the domestic altercation took place when he walked around the building to check for the police for his brother. Those shorts and socks also had red stains consistent with blood that also tested positive for the presence of blood. Texts from the defendant's phone in the months leading up to Ms. Welsh's murder indicate an ongoing and growing hostility on his part towards Ms. Welsh, in which he says many times that he wanted his brother to leave her so that he and his brother could get their own apartment. He says in these messages he wants to choke her sometimes, that he's going to end up killing her if they all move and the defendant's name gets added to the lease so that he can't, quote, be over. Because the fact that he isn't on the lease at the Linway apartment and isn't supposed to be living with them because it is Ms. Welsh's Section 8 is the only reason that he hasn't killed her yet. When she found out she was pregnant, the defendant questioned the validity of that and complained in text messages that he was going to be out on his own because of her, and he continued to say that he wanted to be violent towards her. He also expressed concern that his brother was not actually going to ever leave her. The defendant was interviewed. He denied killing Ms. Welsh. He gave differing timelines and locations for his whereabouts that day and initially claimed to have left the apartment between 4 and 4:30 p.m. on the 30th and going to a nearby Dunkin' Donuts until about 7 when he said he left for his cousin's apartment via Uber. However, when he was confronted with the fact that investigators would obtain video from Dunkin' Donuts and get records from Uber to corroborate his statements, he then said he did go back to the Linway apartment to get belongings between 5:30 and 7 p.m., but claimed he never saw Ms. Welsh in the small one-bedroom apartment, despite evidence of the key fob entries and the cab company that dropped her off at 6:10. He ultimately admitted that he didn't go to Dunkin' Donuts at all, and then said he was in the apartment after his brother got arrested, and he walked around the apartment pacing trying to figure out what he was going to do because he said that he was homeless. He said he walked out at 5:30 p.m., came back in to get his stuff at 7:30 p.m. and was in the apartment for maybe 30 minutes and continued to claim that he never saw Ms. Welsh. He claimed not to fob out of the apartment and had no explanation for the fact that the fob system shows that someone locked the door from the outside using the key fob at 8:16 p.m. Defendant is charged with first-degree murder, and the evidence against this defendant, I would submit to the court, is very strong that he brutally murdered Brianna Welsh, who was also 3 months pregnant at the time of this. Regardless of his lack of prior record and his ties to Massachusetts, he is facing the potential of life in prison. And given the strength of the case, he absolutely is a flight risk, and I would ask that you hold him without bail.
All right, still with us, criminal defense attorney, former prosecutor Jack Rice. Jack, yikes! I mean, you know, we knew some of the facts of this stuff, but now when you start going into the text messages,
yes.
Oh my gosh! And you know, when you look at again the factors that this court's going to consider: severity of the crime, criminal history, community ties. Apparently, she said he has no criminal history, which I find interesting. Community ties, certainly has community ties. Dad lives in the area. Flight risk, I think it's clear he's willing to lie and do what he needs to do to cover up the crime. But yikes, the severity of the crime, and I think the strength of the crime is important, which is why she went through the case for the court.
Oh, no question about it. I always try to argue when I'm in a courtroom, we don't need to go into the facts of the case because those are all mere allegations at this point. What we should be addressing is whether or not they're going to reappear for court or whether or not they're a danger to society. I do understand, as a former prosecutor, I would have done exactly the same thing. It does take me back to just a couple of minutes ago, Michael, when you asked me, how would I defend this case? As I listen to all of this, I think to myself, okay, how do you get a plea to a second-degree murder charge?
Yeah.
How do you do that? And then the next issue that I thought to myself was, is there a way to handle this as a self-defense? And I understand, I'm thinking of it just from a defense perspective, because one of the things that I'm always looking at, I've handled a lot of knife cases, is that you're looking at injuries. And so what you look at is you look at people's hands. What kind of injuries, if any, does he have? Is there anything you can use to hang a self-defense there? Simply, if you're trying to find an answer to how you defend them. But there are some cases where if you end up in trial, it ends up being a slow plea. And the reason you end up in trials like these sometimes is because there are no offers worth taking. What you will sometimes get, because the evidence is so strong, is plead guilty to the top charge, go down as hard as the charge allows. And if you get that, there is, dare I say this, no downside to going to trial. There is no risk.
Mm-hmm. Right.
And there's always some risk for the state. Yeah. That's why you use that pressure to push those charges away from that first degree down to something lesser, usually second degree intentional, second degree unintentional.
Because I think in this case, he may be able to argue, for instance, heat of passion if she got kicked him out of the apartment versus a premeditated. So I would agree that's one approach. We'll see if it's successful or not. Jack, stand by, please. Still ahead, we'll have more key highlights from that bond hearing for Zachary Vozzella. Hear his defense team argue why he should get bail. That's up next after the break.
Cormac.
Welcome back to Court TV Live. I'm Ashley Wilcott here with Michael Ayala, and we have been showing you key moments this hour from a bond hearing in the pregnant woman stabbed murder case for the defendant, Zachary Vozzella. He is charged with murder and assault and battery with a dangerous weapon in the stabbing death of Brianna Welsh, his brother's pregnant girlfriend. Vozzella has pled not guilty.
All right, let's get you back into that courtroom now. We're going to pick it up now with arguments from Vozzella's defense team.
Counsel. Thank you very much, Your Honor. Your Honor, as a preliminary matter, I would like to introduce to the court my client's mother and father who have come for today's proceeding. This is and Lee, his father, will come here to for that. Thank you very much. I know Your Honor has a motion to admit to bail that we filed, and I certainly am not going to read it because Your Honor can read it on his own. But with the court's permission, I'd like to basically bring forth some highlights that I think are important in this particular context. First of all, I've emphasized the fact that my client, Mr. Zachary Vozzella, has no criminal record. When this incident occurred, he was 26 years old. no record. So what does that mean? It means, among other things, he has had no contact with the police. And I'll take that one step further. It's our understanding that when he was interviewed by Lynn police, it was a question of hour after hour after hour after hour. Someone who had been in the system perhaps would have been able to ask the police for some sort of leeway, going to the bathroom, et cetera, et cetera. That didn't happen. This gentleman, because he doesn't have criminal record, was never on probation, never on parole. Also, there have been no orders against him. By that I mean restraining orders, harassment orders, anything like that. So this is his forced foray into the criminal justice system. Then the district attorney mentioned roots in the community. I could stand here for a very, very long time talking about the roots that this gentleman has in the community. I've already introduced His Honor to mother and father. Both mother and father date back generations. His father, Nick, dates back at least 4 generations in Massachusetts. His mother, Lee, dates back to the Revolutionary War. She's a daughter of the DAR, daughter of the American Revolution. And in addition to that, my client was born in Cambridge, Massachusetts, has always lived in Massachusetts, has never lived any place but Massachusetts in his entire life. So if it's a question of roots in the community, that, along with the fact that he has several aunts and uncles and cousins, et cetera, shows that I don't know how you could have a network of people to create a community link as strong as the one we have before us for Zachary Vozzella. He has an employment history as a young man. He worked at CVS briefly, but then he was basically an employee of Amazon and worked in warehouse in Everett. Now, financial resources. Obviously, this young man is in jail. He doesn't have resources. He's been appointed counsel because he is indigent. The whole idea of money, resources, et cetera, is a difficult issue. I've been in contact and communication with the parents, and I asked them, well, how much could you afford to post for Zachary? And they said they could come up with $5,000. I said, $5,000. I said, this is a first-degree murder charge. Yes, and then I hearkened back to what would happen if he were to be released. We thought this through, and we have the specifics. And I know they're in the motion, Your Honor, but just for argument's sake, if he were to be released, he would live with his uncle, Robert Vozzella, who lives in Malden. The complete address is in the motion. He could be on 24-hour confinement, 24/7, 7 days a week, 24 hours a day in confinement. In addition to that, something that's very common these days, global positioning system, GPS, he could have a bracelet on. So all of this, in addition to everything else I said, raises the question: where would he go? No finances and no destination outside of Massachusetts. All of the pertinent elements of the circumstance point to the fact that he's staying in Massachusetts. I understand they say, well, it's first-degree murder, but if you don't have the money, and if you have any place to go, and so where the charges could be there'd be one count of first-degree murder, or 2 or 10 counts, you still can't go. And I think that's the case that we have here before us with this young man. When we take a look at this situation. We did the research to see if we could, in fact, come up with, in fact, viable cases that would speak to the issues. And Your Honor will notice that we talk about Commonwealth v. Vasquez, which, among other things, talks about what the court may consider, should consider, et cetera, and it emphasizes the fact that a major consideration, major consideration is whether or not the defendant, in this case Zachary Vozzella, will show up at his court dates. I mean, is he a flight risk? I suggest that all the circumstances say no, he's not a flight risk. Is he a risk to flee any place? No, he's not. I suggest that, and I think that that's what Vasquez says, that Your Honor can consider that legitimately.
Why do you say that?
Vasquez?
No. Yeah. Why do you say that he's not a flight risk?
I say he's not a flight risk for two major reasons. First of all, he doesn't have the resources to run. Even if he wanted to run, he doesn't have the resources to run. And I'll expand that, not only personally, even if I take into consideration the family. If in fact I reported before Your Honor that the family could put up $250,000 or something like that, I would say, oh yes, now you can say, yeah, there are the resources that something might happen. Unfortunately, Your Honor, that is not the case. So I commend, I mean, I'm not happy about saying this, and these are wonderful people that have treated me and our entire defense team very well, but financially, they simply don't have the means, even if they wanted to, in fact, have him run, which they do not, of course. So, beyond that, and beyond all this, when we've heard from the ADA the version of the facts that happened way back in the end of July. It is now December 17th, I believe. We're almost in the new year. And this is not an indictment of Ms. Bellavia. She's been very courteous to us, and she's very responsive. So I don't want this to be misunderstood. But even as I stand here before Your Honor, we have not received a significant amount of the discovery that I think that we should have had by now. What? Mainly the autopsy report, the medical, and all of the medical documents. I mean, it is what, 5 months, 6 months, whatever it is, and there are serious concerns about what may have happened in that apartment. I agree with that. So if I'm standing before Your Honor on December 17th, and the original arraignment was August 1st in Lynn, and at that point, we written requests for the autopsy and the papers, et cetera, and we still haven't received them. It raises questions in our mind. Now, and we don't know what that information is going to show, but certainly by this time we fully expected to have had the opportunity to review that kind of information, and we have not. I don't know why, and again, I want to be very clear. It's not ADA Bellavia's issue. I think it's beyond that. But in any event, the point is, if we don't have that information, if we can't submit that information to our experts, it puts us at a severe disadvantage, because in effect we're living with the facts that were read into the record, and there's no way to dispute those facts. What I'm saying to Your Honor is this: it's a first-degree murder. Nobody is trying to gloss it over. Nobody's trying to minimize it. Nobody's trying to rationalize it. All we're saying specifically is that this gentleman is not a flight risk. If he were to be released, he'd be here every court day until the final adjudication. That's what we're saying, for the reasons that I've articulated, and I haven't touched them all, but Your Honor has the favorite. I don't want to waste Your Honor's time. So for all those reasons, Your Honor, I would ask that he be admitted to bail. Thank you very much.